In this video, we will deal with the infringement of copyright along with the available remedies. So the main objective of any intellectual property is to prevent infringement and exploit such intellectual property commercially. So that being the objective, we need to know the core rights that are available to intellectual property owners, especially copyright. So some of the rights are translation, adaptation, reproduction, and production. So these are the rights that are available to a copyright owner. So now let's deal with the infringement part. Section 51 of Copyright Act 1957 deals with the infringement. So basically, there is no clear-cut standard as to determine what constitutes an infringement, but infringement is basically generally construed as someone without any authorization uses your works for their personal gain. So the main element here that we can say is that for determining the infringement of copyright would be the permission. If you get the permission to use the copyrighted work, you are not infringing, right? But if you don't even seek any permission, and just like that you exploit such copyrighted work and you get gain out of it, then it will definitely constitute an infringement. So yeah, if any copyrighted work is not being used by someone other than the person who is not the author, and the person is using such copyright work without having sought any permission from the author. Now we will deal with what are the civil remedies and criminal remedies that are available in cases of copyright infringement. Yeah, let's deal with civil remedies that are available. First would be injunction, and then comes the damages and accounts of profit, destruction, and infringement copies. Like in injunction, in the sense the court will order saying that it'll put a stay to continue using such intellectual property, that is injunction. And damages, if any loss that has been caused to the original author due to such unauthorized use of copyrighted work. In such case, compensation can also be granted in favor of the author. And next comes the accounts of profit. If by such exploitation of copyrighted work has resulted in any sort of profit, that is undue profits that has been gained by the person who had infringed, then that accounts of profits can also be given in favor of the copyright owner, right? And the destruction of infringing copies, the court may also order for destruction. Like if there is any pirated versions that are available, the court can prevent it from getting in the hands of getting in the wrong hands. It can destroy such work, that pirated versions. The court also has authority to do so. And then comes the criminal remedies. So if a person wants to choose a criminal remedy, he can approach the court in support of section 63 of the Copyright Act 1957. So in cases of criminal remedy, the accused person will be subject to imprisonment, most probably for 6 months minimum and maximum 3 years. The accused person can also be subjected to fine. The fine amount will be 5,000. The minimum 5,000 fine will be imposed, and maximum would be 2 lakhs. So another remedy under criminal that one can do is that police can seize the infringing copies without even warrant, right? Warrant by the court. So police also has powers to do that. Apart from these civil and criminal remedies, there are other remedies also that are available, such as issuing notices and issuing cease and desist orders. Cease and desist orders in the sense to not to continue such operations. Like if a person spreads all the pirated versions of a particular copyrighted work, then if a court issues a cease and desist order, it should stop. And there is also a scope for alternative dispute resolution, like the parties can go for mediation, right? And the court can also issue ante and pillar orders. So this order is generally granted by the court in cases where search and seizures must be done without any prior notice, because if the person who is carrying out the infringement comes to know that court has given such order, he will be vigilant and he will try to hide everything behind the court, and nothing comes before the public domain. So he might do that, and he can prevent himself from being liable. So the court may issue such orders in such scenarios where the prior notice need not be issued, and the enforcement authorities can directly go and search and conduct seizures, etc. They can do all that. And now we will deal with some of the administrative remedies that are available. So let me give you a scenario, right? So the person has applied for copyright protection, but there is a time that you have to wait till when your registration process gets over completely. Like around it will take around 3 months to 9 months, right, for a copyright to get registered. So the person has applied for the copyright protection, but even before its registration gets completed, he got its intellectual property infringed. Like still, it is still in the registration process, but someone has infringed that work that has already been sent for application. So in such case, the person can approach the copyright office for interim protection, and every applicant. So this is a general rule. One have to remember, like every applicant of the copyright will be given an interim protection from the date of application till the completion of whole process. So in the span of those that span of timeline, the person that is applicant is protected. So for seeking such protection, the author must approach the copyright office firstly. Then only the copyright office would be able to provide remedies to him. So only if the author approaches the copyright office, the remedies will be provided to him. So it can either issue a cease and desist order, or it can inform the court, right? And it is important to remember that always a person to file the application, uh, who has filed the application first, will have the right to get protection. That is the very important point to remember. Like in cases where if subsequently another copyright application has been filed on the same work, the original owner may raise objections before the copyright office saying that uh, another person had made an application with regarding the same work, so I'm just raising an objection. So objections as such nature can also be raised before the copyright office, and thereafter regarding that objection, an objection proceeding will start. So considering all this, we can safely assume that copyright office, which is located in Delhi, is a quasi judicial body. So any sort of appeal that has to be made against the decision of the copyright office will directly reach the high court only.